what could sound difficult. My Lord, the theory of holistic interpretation is mainstreamed as a theory of interpreting our Constitution. Let us then travel back in time to the Bomas Conference. But my Lord, before I do that, allow me to draw your attention to a fresh new publication of the Senate. And that is a digest of the law and practice on removal of county governors and deputy county governors from office through impeachment. First edition, brand new, published last year. I apologize, I haven't yet produced it to the court. I intend to do that, but it's also available online, thanks to the Senate. My Lord, the Senate worries about this process. It says committee vis-a-vis plenary proceedings. And the Senate, this is about governance. It says that the law does not provide for any specific procedure. Page 104, a case digest. You do not have it yet. I've just apologized that I came across it yesterday because it's a new publication, but I will put it on record. When you turn to it and you look at page 104, you find that the Senate says that the law does not provide for any specific procedure. As a result, the county assemblies and the Senate are not bound to follow any route. That is what informs the rules of procedure, where the Senate may investigate. And that is also what informs Standing Order 80, where the Senate may use plenary to investigate. But, my Lord, the Senate recognizes what this court has in Sonko High Court. This court said that we are of the considered view that impeachment of a governor is a serious undertaking. The impeachment of a deputy president, of a president, is a more serious undertaking. For this reason, we recommend that it will be desirable in future impeachments to proceed through the committee route as opposed to the plenary. This High Court has recognized the inherent risks in investigating through plenary. Why? We say so because when the special committee is appointed, the Article 145(3)(a) committee, it has 10 days to deliberate on the matter, thus giving many opportunities to the parties to prepare their cases adequately. The committee gives the perception that each member is actually engaging in the process as opposed to the plenary, which can be perceived to be a mob lynching process. That's exactly what happened here. The investigation in plenary was a mob lynching process. The Senate goes on to say that trial by the committee, page 105, a case digest on removal of governors and deputy governors, a publication of the Senate, brand new 2025 bond. Trial by committee gives the Senate, through the 11 members, an opportunity to review the usually voluminous documents from the governor's team. A trial by committee over the 10 days would have given the Senate the time to review.
As a request, we clarify the record while my colleague is addressing that point. In his written submissions, that decision is described as a decision of the Supreme Court, but it is actually a decision of the High Court. So that we don't have to later belabor this point now that we're addressing it. Can he confirm? Because the written record says it is a decision of the Supreme Court, but it's actually a decision of the High Court.
I'm grateful that my learned friend, Mr. Mudomi Thiankul, a very good friend of mine, felt compelled to interrupt at this point, indicating its importance. It's an easy one. The decision is High Court, Sonko. There's a type of saying it's Supreme Court. It's High Court, but it's what the court has said. Now here, at page 105, where I was, the Senate is speaking to a member of staff of the Senate involved in this process. That's what this report highlights there. And this member of staff, I hope it's my learned friend, Ms. Tanji, is saying that trial by committee, the special committee under Article 145, 3A, gives members and would have given the deputy president's team enough time to interact with the senators on the voluminous record. Because of the fewer members, the committee is able to probe and follow up on specific questions, especially where the grounds for impeachment are technical. Perhaps the committee would have caught out that in Robert Alai, a case I was fortunate to argue with my learned friend, Mr. Ongoya, the court had already nullified Section 132 of the Penal Code on undermining the authority of a public officer. Well, this did not happen in this case. And finally, it records here that the plenary, it also says that there are some benefits to the plenary report as well. My Lord, in short, what you are saying is that the motion to impeach the deputy president was contingent on the special committee's report. It's not just procedural. There's also a substantive right given to him before that committee. Look at Article 145(5) of the Constitution. The deputy president has a right to be heard before that committee. The committee investigating the serious charges leveled against him. That step was omitted. That's a grave violation of the Constitution. My Lord, the final chance that he had to be heard was also denied to him, the adjournment. When something like that happened in a case that my friend, Professor Ochieng, Senior Counsel, argued with his usual merit, Onyango Law versus Kisumu County Assembly Service Board, 2025 Kenya Court of Appeal 333, the Court of Appeal was persuaded that Onyango Law had been denied a fair hearing. And just like in Oloma Law, the Senate here speedily approved the motion, skipped that special committee altogether, but retained the 10-day timeline. I wonder what the 10-day timeline was doing in a plenary setting where the Constitution does not impose that 10-day timeline, but requires reasonableness. It obviously can't delay until the end of the term, but that 10-day timeline was a stranger in the process. And so the Court of Appeal was persuaded that Onyango Law was unfairly impeached. My Lord, we ask you to take the Onyango Law decision and...
I interrupt at this stage. I don't like interrupting things at all. But just out of Onyango Law was given 1 hour. The Deputy President had 10 days.
My Lord, whereas the special committee would have had the deputy president over 10 days, he was investigated in plenary over 24 hours and impeached in his absence. So I ask you again to take the Onyango Law decision, and where it says Onyango Law, please substitute Rigathi Gachagua and make your decision. My Lord, let me take you to the drafting history of our Article 145. It was not initially there as Article 145. And my Lord, the theory of holistic interpretation requires you to consider our social, our political, our historical context as a people. That history has names like Oginga Odinga, mistreated by the president, unfairly removed from office. It has Kungu Karumba, George Saitoti, at some point, not appointed at all, reappointed after the elections. I forget which year, I was a young boy then. But in your ruling of 31st October 2024, my Lord, you recognized this history and you said that the vice president served entirely at the president's mercy. That was a framework that the 2010 Constitution sought to transform. And under the 2010 Constitution, the office of the Deputy President is fundamentally redefined. Your words? It was safeguarded from arbitrary and capricious actions by the President. Before the Senate, on 16th October 2024, another good friend, Senior Counsel Ochieng, a former member of the Committee of Experts, who was familiar with the drafting history of Article 145, reflected as follows, and I quote, "Before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes." So my example of the color of his coat was not so far-fetched. It is on the answered record. My Lord, that's a correct reflection on the intention, on the history, on the motivations, on the framing of Article 145. In the National Land Commission versus Attorney General Supreme Court advisory opinion, the court held that unlike the independence constitution that failed to articulate the history and struggles of the people, the 2010 Constitution integrates that history and the people's view. And so, my Lord, when you turn to interpret Article 145 and you encounter the challenge with the may appearing in the second part of it, in 135 3b, and you wonder why does it appear this way, you must remember the history. Speaking of history, at page 182 of the CKFC final report, and that, my Lord, is a lawyer's Bible, it is a constitutional lawyer's Bible. It is the reference point for ambiguous text. We go back to it to see what was the intention here, what was the struggle, what was the mischief. The people said that, I quote, "there should be adequate mechanisms to avoid the risk of impeachment being used for purely political motives." Page 802 of that CKFC final report records that impeachment was one of the most contentious issues leading to extreme polarization amongst delegates. And the issue was not about the desirability of impeachment. No, it was about the procedure. What procedure do we use? Because we agree that the president must be amenable to impeachment. It is a remedy of last resort. But what procedure do we use? My Lord, in the Bomas draft that came out of